So, good morning to everyone here today. So, first we have to welcome our Mr. Kumanan, our trainer for today. Can we see the screen? So, today we're going to talk about using third-party technology. Is it legal or illegal?
So, uh, as introduced by Goshen, my name is Kumaran from CAS International. I think I'll start the topic today. And our topic for today is on the use of third-party technology. Superior technology is a selling point nowadays, whether it's a power-saving feature for a refrigeration system, latest smartphone, or bioplastics in food packaging. With price and quality being equal, a consumer would prefer a television set with 8K display over 4K, 7.1 audio system over 2.1, and Windows 8 or Windows 7. This is because an 8K display produces superior images over a 4K display. A 7.1 audio system sounds better than 2.1 audio system, and Windows 8 is definitely newer than Windows 7. There's no denying that products with better technology command a higher value. As a business owner, a member of research unit, or a consumer, you may look at these technologies developed by third parties and wonder to yourself, is there any issue using them for commercial, research, or personal purposes? Since these technologies are not tangible properties like a car or a house, it's not an issue if someone else uses them, right? It's not like my wife's or brother's car, where if I used the car for the day, we would end up fighting anyways, and my wife or brother won't have a car to use. Or if you spend the night in your friend's living room, he or she wouldn't be able to iFlix and chill with his or her boyfriend or girlfriend. How would an inventor of a flood mitigation system in the Netherlands be affected if you use his system in Malaysia? It doesn't look like the use of his system would deprive him of his livelihood or adversely affect him in any way. But what if he has patented his system? Most would know that patent rights are recognized by a court of law. Can you use technology belonging to a third party without his or her consent? Is this use legal or illegal? Consider the following scenarios. Let's say A is an owner of a company that produces fitness tracking accessories, and while reading his alumni newsletter, he discovers that as part of their final year project, a team of undergraduate students have developed a program that calculates optimal exertion level based on heart rate and generates an audio feedback when a user under-exerts or over-exerts himself or herself. The program is openly available, licensed, and royalty-free, but the team cautions that they will not be liable for any injury or damage caused by their program. A finds that it is easier and much cheaper to integrate the program into his fitness tracking accessories than to write a new in-house program. So, can A legally integrate their program into his fitness tracking accessories? In the second scenario, B is a Malaysian entrepreneur who went on fruit farm tour in Australia and noticed that the farm uses an intelligent water management system that stores excess rainwater in an underground reservoir and pumps a metered amount of water daily intervals to ensure that the plants are sufficiently watered. Further, the intelligent management system includes a smart roof that allows sunlight to pass through while redirecting water from heavy rainfall to the reservoir. Thanks to the system, the farm is more resilient against drought and flood. Knowing that such technology will be useful in Malaysia, can B implement the same technology in his organic farm in Sergang and sell the technology to other farmers? Next scenario would be C is a producer of smartphones. D is a smartphone shop owner. C's marketing strategy was to launch a particular phone model with a smart technology, selfie technology in Taiwan to test the market before releasing the model in other countries. Seeing the success of the phone model in Taiwan, D expects the phone to sell well in Malaysia and hence decides to buy a large quantity of that model from C's authorized retailers in Taiwan or resale in Malaysia. C has a patent relating to the selfie technology in Taiwan, Malaysia, and elsewhere. Will these actions be considered infringing C's patents? Lastly, Big Pharma's patent on medicine for disease X is about to reach the end of its 20th year term. Can anyone produce and sell Big Pharma's medicine under their own company's name? We'll answer all these questions at the end of the webinar. To help in understanding the subject matter, I'll be covering the following points in today's webinar. First, what are patents? Second, how are patent rights enforced? Third, can you use a third party's technology? And finally, what can you do if you want to use a third party's patented technology? Let's look into the first one. What are patents? To understand if you can or cannot use a third party's technology, we must first understand what patents do and how they relate to technology. Patents are exclusive rights to an invention given to an owner, and an invention meets a certain set of requirements. Firstly, the invention must fulfill the meaning of the term invention as defined by the Patents Act. An invention is something that permits in practice a solution to a specific problem in the field of technology. An invention can take on many forms, such as a method, process, product, system, use of a composition, and so on. Having said that, which of these can be considered an invention? A flu medicine, Da Vinci's Mona Lisa painting, a plate of nasi lemak, or grandmother's secret recipe? If you answered that a flu medicine is an invention, awesome, you're right. A flu medicine or any medicine in general solves a problem, which is how to treat a disease in a specific field of technology, which in this case is the area of medicine. Da Vinci's Mona Lisa painting, while pleasant to look at and may solve someone's problem of having nothing to decorate the wall with, is not an invention, as it does not solve any problem in the field of technology. Likewise, while a plate of nasi lemak does solve our problem of hunger, it does not solve a specific problem in the field of technology. Lastly, grandma's secret recipe. This is slightly tricky because if it is just a closely guarded secret to how to cook the perfect fish curry, which I like the most, then it cannot be an invention. But if her recipe is a series of steps to preserve freshness of the fish without stuffing it into a freezer, then that is an invention because it solves a problem in food science, which is the problem of preserving fish without refrigeration. Next, let's get into the basics. An invention must be new, inventive, and industrially applicable in order to qualify for a patent. For an invention to be new, it must not be disclosed anywhere in the world. A disclosure can be anything and everything disclosed to the public, such as a written document, an oral presentation, or a display of an invention in an exhibition. But remember, the invention must not be something for which another person has already applied for or been granted a patent. For instance, let's say two universities were independently researching psychoactive compounds of mushrooms, and both of them managed to isolate a specific protein that tricks the brain to releasing growth hormones so that adults past puberty could increase in height and mass. And one of the two universities filed an application before the other. The first university's application would be considered new, but not the second university's application. Moving into the second criteria, inventive step. For invention to be inventive, It must not be obvious to a person who has ordinary skill in the field of technology. Ordinary skill in the field of technology meaning a person's skill in the art. Let's look at some examples to help you to understand what is an inventive step. What solutions come to your mind when you encounter these problems? My cup of coffee is too bitter. It's troublesome to carry a pencil and an eraser in my pocket. Lastly, the door keeps creaking every time I open and close it. If your solution to number 1 is to add sugar to the coffee, number 2, get a pencil with an eraser tip, and number 3, oil the joints, then yay, you have discovered the obvious solution to these problems. However, if your solution to problem number 1 is to create an extraction process that results in a cup of coffee without a hint of bitterness, number 2, invent a graphite compound that can be cleanly erased by rubbing the mistake with your fingers, and number 3, create a joint using strong magnets with no rubbing parts so the door won't creak every time you open and close it, then you can be an inventor, because this solution do not appear to be obvious. To the last criteria, inventions must be industrially applicable, which means they can be made or used in any kind of business or industry. This is easy because inventions generally meet this requirement unless they are fanciful or unproven concepts. For instance, a functioning prototype in a lab is industrially applicable, even though it is still at a prototype stage. However, say the concept of constructing an elevator that can go all the way up from Earth's surface to the exosphere. I believe this is definitely not industrially applicable because the present state of technology does not enable one to construct such an elevator. It's clear now, right? Ultimately, an inventor who wishes to obtain rights must apply for that right to be awarded to him or her. Thereafter, Patent Office will examine the application and make a determination whether the applicant's invention is patentable. So long as an invention meets all the 3 requirements that I just mentioned, novel, inventive step, and industrially applicable, a patent may be awarded to an inventor or applicant. The next question would be, what rights does a patent owner enjoy? Patents are awarded to inventors or applicants to reward their inventive effort. In exchange for sharing the necessary knowledge to reproduce their invention, they enjoy exclusive rights to their invention for a limited period of time, which is 20 years. These rights include the right to exclude others from using, selling, offering for sale, producing, or stocking their patented product. If their invention concerns a process, then the patent also allows them to exclude others from using their process and to obtain a product using their process. Next, a patent owner gets to decide who can use his or her invention, and if he or she wishes to grant a license to another party to use his or her patented invention in exchange for license fees. Patent owner may also sell his or her patent to another party by assigning the rights to his or her patent to a third party for money. As mentioned earlier, remember a patent term lasts 20 years from the date of the application was filed. During this period, if a third party were to use, sell, offer for sale, produce, or stock a patented product without a patent owner's approval, this act is considered an infringement of the patent, and the patent owner can seek damages from a third party who has infringed his or her patent rights. So, if an inventor has a patent for his technology, the inventor is able to exclude others from using his or her technology. Second point of the day, how are patent rights enforced? You read about a patented durian cracker that cracks open a durian fruit and extracts all the flesh in one single action in a magazine article. You see that there is a good market for this durian cracker in Malaysia. You want to make and sell this durian cracker. Can you use a person's patented invention without that person's approval? What happens if you do? Have you committed a crime that is punishable by law? Will the police come after you? Do you have to spend the rest of your life as a fugitive, hiding and changing identities? Should you get a St. Kitts and Nevis passport and slip through Bukit Kayu Hitam into neighboring Thailand to avoid arrest? Perhaps the best question to ask yourself now are this: how does one enforce his or her patent rights? Who is responsible for enforcing patent rights? Is it the customs? Is it the police? Is it the Ministry of Domestic Trade, Cooperative and Consumerism? Or is it the Patent Office? Actually, the responsibility is on the patent owner itself to enforce the exclusive rights that is granted to him or her by the Patent Office. Police or the customs do not patrol factories or warehouses to crack down on patent infringers. Neither do inspectors from the Ministry of Domestic Trade, Cooperative and Consumerism inspect every product placed in market to ensure that they do not infringe any patent that is in force. If the patent owner finds that a third party is infringing his or her patent rights, patent owner may seek damages and other remedies through the courts. Okay, so one thing to note is that patent infringement in Malaysia is not a criminal offense. It is a civil offense. The distinction between a criminal offense and a civil offense is that for a criminal offense, the offender is punished for committing the offense, while for a civil offense, the offender is asked to repay or compensate the loss of the other party as a result of him committing the offense. For example, when a person has been caught and proven to have committed an act such as murder, robbery, or rape, the person is said to have committed a criminal offense, which is an act that is punishable by law, and so the person pays a fine or goes to jail. In contrast, if person A has been spreading lies on social media about person B's fidelity to his wife, causing person B to be humiliated and shunned by family members from both sides, and as a result suffer clinical depression, person B can bring person A to court and sue person A for defamation, which is a civil offense. Person A, if proven in court to have committed the offense, will have to compensate person B for damages suffered. Similarly, for patent infringement, a patent owner can sue another person for infringing his or her patent and claim damages from the infringer. For this to happen, a patent owner must have a valid patent, a competent lawyer, prove that the other party has infringed his valid patent and as a result he has suffered some loss, and lots of money. Most importantly, the patent owner has to take action against the infringer, and if the patent owner fails to do so within 5 years from the date of the act of infringement, I would like to emphasize here, within 5 years from the date of the act of infringement, patent owner cannot initiate any infringement proceedings. So, if the patent owner fails to act, the person who is infringing the patent owner's patent will not be properly motivated to pay any compensation. Third point, can you use a third party's technology? Now that you know how a patent owner can defend his or her patent rights, we now ask ourselves the following question. Can you use a third party's technology? Is it okay to use a third party's technology without their consent? The easy answer is this. If you bought a product bearing the technology from the owner of the technology or his or her licensee, or if you have obtained consent from the owner of the technology to use his or her technology, then yes, you may do so. But all inventors who have developed new invention want to keep their inventions to themselves. There are some truly selfless inventors who are not out there for profit. These are inventors who invent new products or technologies and make them openly available for others for their betterment of life. These technologies may fall under a category called open source technology, where the technology is free for others to use, inspect, modify, or improve. An example of such an open source technology is the Arduino platform. Sorry, just give me a moment. Yeah. The Arduino platform is a microcontroller hardware and software system that can be used as an educational tool to learn programming and robotics or as a controller for electrical devices. The hardware system is a microcontroller board which can be connected to a battery, sensors, and other devices. You can use the Arduino programming software to create a program that can be then loaded onto the microcontroller board, and the microcontroller board will then execute the program which you have created. For instance, if you wanted to give your favorite dispatch a bit of scare, you can connect the Arduino board to a speaker, proximity sensor, and storage containing the recording of a very spooky voice. You can then program the Arduino board to play the recording whenever the proximity sensor detects the presence of an object. So when Mr. Dispatch Guy arrives at your doorstep to drop your package, the proximity sensor will detect his presence, sending a signal to the Arduino board, which then plays the recording to the speaker and thus spooking the poor guy, causing him to drop by your fragile Thanos imitation Infinity Gauntlet. I don't think so. It's a good idea. Being an open source platform, the creators of Arduino have made the schematics, programming software, and other resources available to the public. Others can freely create their own Arduino boards without having to pay any licensing fees or requesting permission from the creators. Generally, you're free to use open source technology, but there may be some restrictions placed by the inventors regarding distribution or commercial use of their technology. For example, most creators of open source software will prohibit sale of their software to another party since they have made that software free for download, and the act of selling their software for money goes against their original intention. Other creators may allow commercial use of their software and invite other like-minded creators to collaborate with them to further enhance their existing technology. In any case, if you wish to use open source technology, it is good to know what you can and can't do with the open source technology. And it goes without saying that you should not abuse the goodwill of those who have created and made the open source technology available for your use. Now, what if you want to use a third party's invention without their consent? Can you do that? Will you get served? In some cases, patented technologies can be used without infringing a patent. To recall, infringing activities include any act of using, selling, offering for sale, producing, or stocking an invention that has been granted a patent. However, some activities are considered to be non-infringing activities by law. In Malaysia, use of patented technology for scientific research purpose is a non-infringing activity. It is a no-brainer if you think about it, since the patent system is intended to reward innovation, and it would be against the spirit of establishing the patent system if the patent system for rewarding innovation became an obstacle to scientific progress. Another non-infringing activity is the production, use, or sale of a patented invention for development and submission of information to a relevant authority which regulates the manufacture, use, or sale of drugs. So if your job required you to synthesize ED drugs, test and observe its effect in order to submit a report to the Ministry of Health, then said act of synthesizing and testing or R&D would not be considered as an act of infringement. In other cases, Use of patented technology will not be infringing if the owner doesn't actually have a patent right in the market where you intend to exploit the technology. This can happen when the subject matter of the invention is not patentable subject matter in the country. Patentable subject matter differs from country to country. Generally, most countries do not allow patents that relate to what? Discoveries, scientific theories, and mathematical methods. Number two, plant or animal varieties are essentially biological processes for the production of plants or animals other than man-made living microorganisms, microbiological processes, and the products of such microorganism processes. Three, schemes, rules, or methods for doing business, performing purely mental acts, or playing games. And lastly, methods for the treatment of human or animal body by surgery or therapy, and diagnostic methods practiced on the human or animal body. However, in countries such as US and Australia, business methods and methods of treatment are patentable subject matter. So please, if your market is in Malaysia and you saw this amazing business method patented in the US that could work very well in Malaysia and would like to exploit that business method in Malaysia, you would not be infringing any Malaysian patents since the American patentee can't have a business method patent in Malaysia. But patent may have other subject matter that can be patented in Malaysia, such as but not limited to an apparatus or a system that is used to implement the business method. So be careful. Even you do find that a technology is patented overseas, but no corresponding patent was applied for in the country where you wish to use that technology, it would be good to be aware that patents are only one form of IP right. Do consider that in addition to a patent owner may have other rights subsisting in your territory, such as, but not limited to, trademarks, industrial designs, and copyright. Do remember not to fall afoul of the patentee's other IP rights as well if you intend to use his or her technology. Final point of today's webinar. What can you do if you want to use a third party's patented technology? Now that you know about open source technologies and patented technologies, how do you determine if you can use a patented technology while minimizing your risk of getting served? If you learn about a patented technology and wonder if you are free to use that technology without infringing the patentee's rights, you can search your local patent database to see if there is a corresponding patent or patent application in your country. If no patent subsists in the country where you wish to exploit that third-party technology, then you should be able to use that technology without worrying that someone will take you to court for patent infringement. If you do find that a valuable technology which you would like to use as a corresponding patent in the country where you wish to exploit that technology, it's not a good idea to ignore the existence of the patent, since if the patent owner brings you to court and it is proven that you knew about the existence of the patent and choose to ignore it, damages that are payable to the patent owner may be greater. You may instead wish to consider obtaining a license from the patent owner. Patent owner may be open to licensing his or her technology to a third party, especially if the patent owner is not a manufacturer or producer him or herself, as more licensing means more income. Money, money, money. Additionally, cross-licensing is a common practice in many industries. So it's not surprising to see a company's product incorporating proprietary technologies of its competitors. Business owners have come to realize that suing the pants off each other for patent infringement is counterproductive and bad for business, since it will result in no winners and many pantsless business owners. If for some reason the patent owner is reluctant to license their technology to you, or is doing so at an extremely unreasonable rate, you may apply for a compulsory license at the Patent Office. If the Patent Office is satisfied that you meet the conditions for a compulsory license, then you will be able to obtain one at a rate and duration that is determined by the Patent Office. Alternatively, if it makes more business sense, you may acquire that patent instead. Acquiring patents would be more costly than licensing fees. But then, if it is foreseen that over time, the acquisition of a patent is cheaper than the cumulative licensing fees, then by all means go for it. The added advantage of acquiring the patent instead of paying licensing fees is that once you have acquired the patent, other parties will have to pay you licensing fees for the right to use your technology. Now, coming back to the questions we raised in the beginning, here are the answers. For the first scenario, if you recall, A and his fitness tracking accessories, the question was, can A legally integrate the undergraduate program into his fitness tracking accessories? The answer is yes. A can use the undergraduate program in his fitness tracking tool since it is available, licensed and royalty free. However, A must be careful not to violate any open source licensing agreement that may be put in place. In the second scenario, where B would like to use the intelligent water management system that he learned about in Australia, question was, can B implement the same technology in his organic farm in Sargam and sell the technology to other farmers? This depends on whether the inventor of the intelligent water management system has a corresponding patent in Malaysia. If yes, then B will be liable for infringement action since the use and sale of a patented technology are considered as acts of infringement. If on the other hand, the inventor does not have a patent in Malaysia, then B will be able to implement and sell the technology since the inventor does not have a subsisting patent right relating to that technology in Malaysia. Third scenario was, which was between C, a producer of smartphones, and D, a smartphone shop owner. Question was, will these actions be considered as infringing C's patents? The answer is, under the Malaysian Patents Act, these actions cannot be considered infringing C's patents, as the smartphones were purchased from C's authorized retailers in Taiwan. However, D will have to be careful with how he markets the smartphone so that he does not get entangled with trademark-related issues. For example, since he is not an authorized distributor of C's product, he must not claim to be such. Otherwise, he can face legal action from C. In the last scenario, regarding Big Pharma's patent, question was, can you produce and sell Big Pharma's medicine under your own company's name? Yes, you may produce and sell Big Pharma's medicine under your own company's name once and only once the patent expires. However, you must be careful not to infringe any of Big Pharma's other IP rights, which may still be subsisting. For instance, if the medicine was sold under a particular brand name, you should not use that brand name as a means to identify the medicine being sold, since the brand name may be registered and still be in use. Additionally, you must be aware that sale of medicines are regulated by the Ministry of Health, and necessary steps should be taken to secure any regulatory approval before selling the medicine. To wrap it up, here are the points we discussed. The first point was, what are patents? Patents are exclusive rights to an invention given to an inventor for inventions which are new, inventive, and industrially applicable. The exclusive rights of a patent owner are: A, the right to exclude others from using, selling, offering for sale, producing, or stocking a product that is covered by his or her patent. And B, for a process, the right to exclude others from using the process and to obtain a product using the process. C, the right to conclude license agreements, and lastly, the right to assign the patent to an assignee. Remember guys, the exclusive rights to a patent last 20 years from the date of filing, not more than that. Point 2 was, how are patent rights enforced? The responsibility is on the patent owner to enforce his or her patent rights. Patent infringement is a civil offense and not a criminal offense. Patent owner has to initiate infringement proceedings, as I emphasized just now, within 5 years from the date of the infringing activity. Otherwise, game over. Third point was, can you use a third party's technology? You can use a third party's technology if you have brought a product bearing the technology from the third party or obtain permission from the third party to use their technology. Open source technologies are free to use, but consider what are the conditions set by the inventors. Patentable subject matter can differ from country to country. There is no patent infringement if no patent right exists. The last point was, what can you do if you want to use a third party's technology? As a first step, please conduct patent searches to see if a patent owner has a patent in the market where you wish to exploit the patent owner's technology. And if a third party's technology is patented, please consider obtaining a license from the patent owner or applying for a compulsory license if the right requirements are met, or acquiring the patent itself from the patent owner. Last piece of advice before I end my presentation. Like your neighbor's unsecured, unlimited high-speed broadband Wi-Fi may be tempting to use a third party's technology without their knowledge or consent. After all, what's the harm? But unlike your neighbor, who may make the Wi-Fi secure, hidden, or at most blacklist your MAC address if he or she discovered that you have been freeloading off their Wi-Fi, a patent owner can bring you to court for losses suffered, and you will pay dearly for infringing his or her patent rights. So, don't freely assume that you can freely use technology belonging to a third party, unless you are really sure that you can. And if there is any doubt, it is best to consult an IP professional like yours truly from CAS International. Thank you, and let's move on to any questions you may have. I'll pass the floor to Goshen.
All right. Okay. So hold on, yeah.
Yep.
Right. So right now we'll have a 5 minutes break, and thank you to Mr.
Right.
Kumanan. Maybe you can rest for 5 minutes. So in the meantime, if anyone has any questions, you can type it out in the chat box. Then after 5 minutes, Mr. Kumanan will come back and he'll try to answer your questions. So is that
Great.
okay? Yeah.
Yeah.
So we'll take a 5 minutes off, and then in the meantime,
Sure.
write down your questions, yeah? So you can write them in the chat box.
Or you guys actually can email us also. I can drop an email and we can also reply you by email. Is there, okay, can I see what are the questions? Do you have any
Yeah.
questions?
Or Mr. Kumanan, do you want just to go on with answering the questions?
Yeah, let me scroll down. Oh, question is only two, right? Okay, so there's a question from Naz. Let's say other prototyping device bought on Okay, how about co-branding? For example, Arduino board, or let's say other prototyping device board. On my product, I have their brand name. Should it be an issue? Okay, let me clarify your question. So you're asking if you put somebody else's brand name in your product, is that an issue? Nes, can you maybe you can reply to me saying if my question was correct?
Nas, are you around?
Yeah. Uh, okay. So let's say I assume if the question is what if you put someone else's brand name into your product? Will there be an issue? Okay, I'll assume the question is that. Okay. Firstly, as I said, before using someone else's trademark, you need to ask, you need to have their consent, otherwise it's wrong. Or you can get actually license from them to use their brand name. Otherwise, definitely it is not right. I believe I've answered your question. So basically, you need a consent from the owner, or you can get license from them. And SP, okay. Question from SP: do we need to wait till the patent is granted before taking legal action for infringement? Yes, the answer is yes. You need to get a patent granted. However, you can actually drop, while the patent is pending, you can actually drop a warning letter to those who you feel infringing. But however, you can't enforce your rights until your patent is granted. I believe I have answered SP's question as well.
Mr.
So
Komanan?
the question was, what if it takes more than 5 years for the patent to be granted? The second question was, how long do we need to wait for a patent to be granted? I would like to combine these uh, questions together so that my answer will cover both. So basically, in general practice in Malaysia, it will take 4 to 6 years for the patent office to issue an examination report, the first examination report. So the first examination report can be an adverse examination report, or it can be a clear report. So if you get a clear report, then you must wait for about 4 to 6 years, as I said. Let's say if it's an adverse examination report, we need to revert back to the examiner and convince them why our invention is patentable. So basically, the examination report will cover on the grounds of patentability requirements, if your invention meets or doesn't meet novelty, inventive step, or industrial applicability requirements. So you may wait if you want. Otherwise, you can actually expedite examination in Malaysia. We have an option of expediting the examination, but of course, it will take. You need to spend more than the usual amount that you spend for requesting examination. So by expediting this examination, you can actually shorten the period within a year to be actually within 6 months, but let's give a longer, a safer timeline of 1 year. Okay, but 6 months you can get an examination report from patent office. But remember, this expedited examination will only work once you file a normal request for examination, and the examination will only begin after the publication of your patent application, which is after 18 months from the date you file the application in Malaysia. Right? If you, let's say, I can just share with you what are the grounds needed for the registrar to accept your request for expedited examination. One of those are, if you feel or if you see someone infringing your invention, or if you need to commercialize your product or your, let's say, your method or process or system, And lastly, if it is a green technology, you can actually request for expedited examination. So I believe I answered both SP and Vijay's question. If there is no more question, then you may drop us. If let's say you have more questions, and but you can't think of any now, you can actually drop us an email, and I can write back to you, or any of our team members can revert back to you. Our email would be KASS. Oh yeah, set that Miss Ivana has wrote there. That's our email address. cas@cas.asia. KASS at kass.asia. Thank you.
Yeah.
Goshen?
So, all right, thank you. So if you have any questions, do feel free to message Mr. Kumanan at cas@cas.asia. So you can see in the chat box. So before we call it a day, because there's no more additional questions, right? Okay, so before I call it a day, I just like to ask for some feedback. So if you think that you are happy with today's sharing session, say happy. If you're not happy with it, just say not happy so that we can try to improve. Okay? So
I'm happy.
to all right, thank you, Mr. Khan. Mr. Kumaran. All right. Sorry, I'm a bit nervous because it's still my second time. But yeah,
This is my first
believe
time anyways.
everybody, yeah, it's very happy with Mr. Kumaran's session. Okay. All right. So do leave us a feedback, yeah? Okay, Ivana is happy. Vijay is happy. Nas is happy. Divania is happy. Thank you, everybody. SP is happy. All right. So mostly the feedback is good. All right. So, but we'll try to make certain improvements, yeah, after reviewing today's session. So I think that should be all for today. So once again, we'd like to
Yep.
thank Mr. Kumanan for your sharing. Thank you very much. And thank you all the ladies and gentlemen online here today. Thank you for being with us for this session. And I hope that everyone has a nice day. All right. Thank you, Mr. Kumanan. Thank you.
Thank you, Goshen, and thank you everyone for tuning in. Feel free to drop us an email if you need any other clarification. We'll be more than happy to assist any of you. Thank you very much.
All right. So that would be all. So thank you, everybody. We see you next time.